Lawyers criticize proposed THC regulation. Lawyers say a government proposal to criminalize having a certain amount of THC in your blood 2 hours after driving will likely face a charter challenge if implemented. A group of prominent criminal defense lawyers recently signed a letter calling on the government to abandon part of the proposed regulations in Bill C-46 that would establish a summary of NCE for people found to have more than 2 nanograms THC in a milliliter of their blood within 2 hours of driving a car. Lawyers say the proposal would disproportionately affect people who consume the drug for medical purposes and is contrary to S. 7 of the Charter. There are a lot of flaws in the legislation, says Caryma, a criminal defense lawyer and one of the letter's signatories. I wouldn't be surprised to see a constitutional challenge. The letter points to 2 studies from 2009 that found a large number of regular cannabis users still have 2 of THC in their blood after abstaining from the drug for a week. SAD says that while it is important to keep roads safe, the court system should not be clogged up with people facing charges who are not driving in a dangerous way but simply have THC in their bloodstream. THC doesn't necessarily impair someone's ability to drive, and depending on how an individual chooses to use and how often they consume, they may not actually be impaired. SAD says, a more individual case-by-case is a more appropriate solution than sort of an arbitrary number that doesn't necessarily reflect what the reality is. She adds that such testing cannot be relied on yet as the science around it has not advanced enough. There is no telling how long it would take for the readings of a habitual marijuana user to come down to a level that is deemed appropriate, whether they smoked recently or not, she says. Sometimes, the science can seem determinative when in fact it's not, and we're not at that stage yet, she says. Harrison Jordan, an articling student in cannabis law at Lewin and Segarra LLP, organized the letter as he felt the offense was overbroad. More than 50 lawyers from across the country have signed the letter. Jordan says that the 2 threshold will criminalize many Canadians who are not impaired and should not be charged. We think that if the government takes out the 2 the sky won't fall, just as the sky hasn't fallen in Colorado and Washington, where they have the presumptive 5 threshold, he says. In a backgrounder on the regulation, the government acknowledged that the proposed summary conviction offense is not directly linked to impairment, but it is, rather, based on a precautionary or crime prevention approach. Criminal defense lawyer Michael Spratt, who also signed the letter, says a criminal record for this offense could prevent international travel, limit employment opportunities and preclude full participation in society. This is especially true given that we know there will be a disproportionate impact on visible minorities and marginalized members of society. This is a shocking and unprecedented use of criminal law power. He adds that the law is irrational, not based on evidence and overly broad. Ian McLeod, a spokesman for the Department of Justice, said the government has received the letter and will review it along with other comments submitted during a 30-day consultation period that ended November 13. McLeod said the bill that proposed new offenses would be set by regulations rather than the criminal code. Setting the levels by regulations would ensure that the levels can be quickly adjusted to respond to scientific developments or to add new drugs, he said in an email. The proposed level of having at least 2 but less than 5 of THC per milliliter of blood is a precautionary approach that takes into account the best available scientific evidence related to cannabis and driving. Going forward, the regulations will not be finalized until Parliament passes Bill C-46.